A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. It's one of those days where there's so much going on. And by the time you actually watch this, there is a chance, I won't predict how good a chance it is, but there is a chance that a judge in Effingham County, Illinois, will have granted a restraining order against enforcement of the state's new ban on so-called assault weapons and large-capacity magazines. As we reported at Bearing Arms this morning, there are multiple lawsuits now filed in Illinois. More to come, by the way, but the first hearing held in Effingham County on a complaint that alleges the way this gun and magazine ban was approved by the legislature violated state statute. Basically, the legislature is required to follow single subject rules in lame duck sessions, and the plaintiff's attorneys in this case arguing in Effingham County that that did not take place, that in essence a bill that was originally about insurance was stripped, and then the gun ban and magazine ban language was put in place. Again, we'll see how well that argument goes in Effingham County, but that is just one of several lawsuits underway. We are following them all at Bearing Arms. On the program today, however, we're going to be talking about pending legislation, stuff that is not yet law, but is likely to become law in another blue state where, unfortunately, anti-gun Democrats gained seats in the legislature back in November. That's the state of Maryland. And on Tuesday, a Senate panel heard testimony about how the Bruen decision, which struck down New York's May issue carry laws, will impact Maryland's gun control laws going forward, not just with the right to carry, although that was a big topic of the conversation, but with the state's ban on so-called assault weapons being challenged in court as well. Lawmakers wanted to hear from well, I don't know if Democrats wanted to hear from gun owners, but they did get an invite. The Maryland State Police, interestingly enough, telling this Senate Judicial Proceedings Committee that it has approved 80,000 concealed carry permits since the Bruen decision was handed down, and then Governor Larry Hogan directed the state police to remove the justifiable need requirement. By contrast, they say the average annual permit approvals for the years prior to Bruen was between 13,000 and 14,000, meaning that the Maryland State Police has been, quote, handling every month what had been about a year's supply of permit approvals. Now, think about that for a second. The pent-up demand to exercise this fundamental right that this represents, right? 14,000 concealed carry permits per month now since the Bruen decision. And for a lot of Maryland residents, it's still not that easy to get the training that's necessary. There are long wait times. There aren't a lot of ranges in the state of Maryland where you can go and you can get the in-person training that is required under the law. So the state of Maryland still doesn't make it an easy thing for you to exercise your right to either keep or bear arms, quite frankly, because you have to get what's called a handgun qualification license before you can even possess a handgun in the state. Yet another law, by the way, that is constitutionally questionable in light of the Bruen decision. Now, at Tuesday's hearing, Mark Pinnock from Maryland Shall Issue was among those testifying. And he warned them, legislators, not to repeat the mistakes that we've seen in places like New Jersey, New York, where, you've really just seen this tantrum. I think it was the word that the Gun Owner Action League's Jim Wallace used on yesterday's program, this temper tantrum in response to the Supreme Court's decision saying, yeah, the right to bear arms is just as fundamental and real as the right to keep arms. And you can't violate that either. Pinnock, in written testimony, criticized a bill we've talked about at Bearing Arms, introduced by Senator Jeff Waldstreicher of Montgomery County, which would ban gun possession within 100 feet of places of, quote, public accommodation, which is basically anywhere the public might gather. Retail stores, restaurants, churches, parks, libraries, hospitals. Pinnock, in his testimony, said that the Supreme Court has been, quote, quite specific that there are only 5 sensitive places where gun possession can be banned: legislative assemblies, polling places, courthouses, schools, and government buildings. He said once you go beyond that 5, you're going to have to find an historic analog, and that there are no historic analogs to banning gun possession in places like restaurants, houses of worship, parks, libraries, and hospitals. Yeah, so it is true that the Supreme Court did not say that that list was exhaustive, right? They enumerated, I think, just a couple of places, actually. Not even all government buildings, but legislative assemblies, courthouses, and polling places, I believe, were the 3 that were mentioned specifically by Justice Thomas in the Bruen decision. But while Thomas said, look, we're not trying to provide a comprehensive list of every place where guns can be banned, when you look at the historic record, what you see is that these bans, these sensitive places, were very much the exception and not the rule. And that was the point that Clarence Thomas was trying to make in the Bruen decision, that the number of places where you could lawfully ban the possession of firearms are in actuality few and far between, which is the exact opposite stance that, Senator Waldstreicher has taken. And actually, Montgomery County, Maryland, has already approved an ordinance that is very similar to the one that is proposed at a state level by Waldstreicher. Senator Will Smith, also of Montgomery, chair of the panel that heard testimony on Tuesday, questioned whether laws banning gun possession in public parks would violate the Second Amendment and be susceptible to legal challenges. And Mark Pinnock said, yeah, they do. And I'll bring those legal challenges, which is good to hear. However, there were gun control advocates who were testifying as well. Sam Levy, counsel for Everytown for Gun Safety, told the Senate committee that the Supreme Court in Bruen left open the question of whether and what other places may be statutorily marked as gun-free zones based on historical analogs without violating the Second Amendment right to keep and bear arms. Levy said that he anticipates it'll take an, quote, uneasy 5 years at least before the courts decide where gun possession may be banned. He said it is a wrongly decided case, speaking of Bruen. But he added, it is the law of the land now. The upshot is going to be more guns in more public places. Well, it's only wrongly decided if you think the Second Amendment is meaningless, or maybe the Bill of Rights, or maybe the entire Constitution. But if you do believe that the Bill of Rights protects important fundamental freedoms that we possess as American citizens, then no, the Bruen decision was not wrongly decided, because the May issue laws that were struck down by Bruen deprived the vast majority of average Americans from exercising that fundamental right. Now, I do think Levy's right that it is going to take some time for all of this to shake out. 5 years, I think we'll have a lot of additional case law on the books, and I predict that the vast majority of which is going to be favorable to gun owners and Second Amendment supporters over the next 5 years. But the fight, quite honestly, is never going to stop as long as you have people intent on trying to infringe on a fundamental right. The courts are going to continue to be asked to weigh in as long as the infringements are happening here. If the gun control lobby ever decided, all right, you know what, we've lost trying to ban our way to safety or trying to disarm the American public, this isn't going to work, maybe let's shift our attention to fully supporting things like, gun violence prevention programs that don't involve putting new laws on the books that focus on the most violent offenders. But that day isn't here yet. And I don't know if that day, honestly, will ever come. So in the meantime, yes, we are going to continue to have to defend our right to keep and bear arms from those egregious and unconstitutional attacks. In Maryland, unfortunately, is likely to be one of those places this year, with the sweeping bans on concealed carry that we've seen in places like New Jersey and New York, assault weapon bans like the ones that we've seen in Illinois. We might even see the state of Maryland try. They've already got one in place. In fact, it's being challenged at the Fourth Circuit Court of Appeals right now. But they could go back and try to expand their gun ban, just as Democrats in Massachusetts are talking about doing by redefining assault weapon to mean all semi-automatic rifles and shotguns, right? So keep your eyes on what's going on in Maryland. If you are a Maryland gun owner, I would obviously encourage you to support groups like Maryland Shall Issue, as well as national 2A groups. This is a supercharged moment for the Second Amendment. And the more of us, look, we can't all be named plaintiffs. as fun as that might be. But we can all lend our support, including, opening up our wallet and kicking in a couple of bucks to these lawsuits whenever we can in order to protect our rights. Because what happens in Maryland, what happens in New York, what happens in New Jersey or in Illinois doesn't just impact gun owners in those states, right? The legislation, once it becomes law, is often replicated in other states around the country. And of course, if these unconstitutional infringements are allowed to stand in these blue states, well, you never know what might happen in red states in the future, right? All right, let's turn our attention now to today's Armed Citizen story, our good deed of the day, and our recidivist report. In fact, we'll start with a story. I don't know if any of these, nobody's been arrested here. But I'm going to go out on a limb and say at least one of these guys responsible for this crime probably does have a record here. Hell's Kitchen. A smoke shop worker shot when at least 5 men tried to rob the store. Now, of course, retail establishments in New York and Hell's Kitchen might be close enough to Times Square that this would be an official gun-free zone. Not allowed to carry a firearm for self-defense. So this was one of New York's gun-free zones. Not that the criminals seemed to care. Early this morning, just after midnight, 5 men trying to rob the shop located on 9th Avenue between 48th and 49th Streets. There was a worker inside the shop who tried to kick out the men. That dispute then spilled out on the street. Police say one of the men pulled out a gun, shot the worker in the leg. Then the suspects all took off, several of them on scooters. The 32-year-old employee taken to a local hospital with non-life-threatening injuries, thankfully. Police say they're now reviewing the security cameras outside the store, which may have caught the incident. But again, no arrests made at this time. And thanks to New York's egregiously unconstitutional carry laws, no ability for retail workers in smoke shops in Manhattan or, near Times Square to actually protect and defend themselves against violent criminals who, strangely, don't seem to care that they're violating New York's carry laws. Today's defensive gun use, our Armed Citizen story. Again, this is something that's been coming up quite a bit, right? Shouldn't we have laws on the books that make it illegal for juveniles to access firearms in the home? We saw that incident in Virginia last week where a 6-year-old gained access to a gun, brought it to school. Apparently, the school was alerted that the child might have a gun. They searched the backpack, didn't find it, didn't search the student. Student ends up pulling the gun out of his waistband and then shoots his teacher. And so in Virginia, there's a lot of talk. I mean, that's where I live. So I know there's a lot of talk right now about, well, what can we do to stop this from happening? As if there is some law that you can put in place that's magically going to improve the parenting or frankly, the decision-making in the schools when it comes to responding to reports of a gun on campus, right? Now, instead, they're looking at, storage laws. What can we do to increase the penalty if a juvenile gains access to a firearm? I'll be honest with you. Does a 6-year-old need access to a firearm? No. But should it be up to the parent to decide when juveniles in their home do have access to firearms? Once you get to a certain age, whether it's, 10, 11, 12? I think the answer is yeah. And unfortunately, these storage laws are generally written in a way that if any minor accesses a firearm, then the adult in the house has committed a crime. And the problem with that is that sometimes you have stories like this. Teen stops home invasion with mother's handgun. So, should the mom be charged here? What do you think? Case out of Montville, Ohio, where a teenager, Braden Jarrett, says he was home from school last Tuesday, and he was just looking out the living room window when he noticed a car parked sideways in his driveway. And he said it was there in the driveway for a little bit. He said, I walked into our kitchen because we have a window in the kitchen, and I looked out, and I saw the dude, and I've never seen this dude in my life. So Jarrett, 16 years old, knew that his mom kept a firearm in the house, 9mm handgun, and he knew where it was. He says he was familiar with firearms, grown up around him. He said, my mom had a gun. I knew it. I grew up with guns. I knew about the safety. I knew where the gun was and everything. Ashley Jarrett, Braden's mom, says, my gun's unloaded. Clip is next to it. He knows where it's at. So he grabbed it and he held onto both pieces and he stood in the living room doorway. Braden Jarrett says he stood there watching the door, heard the outside screen door open, and he knew that if it was, an Amazon driver or somebody dropping off a package, that they would then shut that storm door and they would leave. That's not what happened. Instead, they started opening the inside door. And that's when Braden Jarrett says he loaded the gun. He says, I didn't say anything, but when I cocked the gun back and pointed it at the door, he said, oh, bleep. And then he ran. Braden immediately called his mom at work. She said, when he called me, he asked questions like, did you have anybody coming over? Were you expecting any packages? And then he said, well, I think somebody tried to break in and I had to pull your gun. Now, what's amazing about this story is that an arrest was actually made. Braden says the car drove past the house again. His mom ended up posting about the break-in on social media, and the neighbors helped to identify the car. The Goya County Sheriff's Office was able to pick out a suspect out of a photo lineup, and the Sheriff's Office has now charged Zachary Stutzman of Hartsgrove, Ohio, with burglary. Ashley Jarrett says she knows Stutzman as a friend on social media, so they might have mutual acquaintances in real life, but she's not ever really met him before. She thinks he may have used her post to try to learn her routine. And knowing that she was out of the house, thinking that her son was at school, aha, easy and inviting target, right? But they were only into the second day of a new routine for her son. And generally, he would not have been in the house, but he was that day. Ashley Jarrett's now cautioning people about what they post on social media. She says, anybody can see your schedule. If you're just posting that you're at your place of business or you're posting you're out and about and someone who's mostly alone, it leaves you open for vulnerability. And it gives somebody a key into your life. Ashley Jarrett, by the way, says that she is grateful to have a teenage son who not only can protect himself, but can protect her as well. She said, I have more anxiety about this than he does for sure. She said, I lined up the school, told him to set up a counseling meeting if he needed it. And his exact words were, I'm not afraid of guns. All I had to do was pick up a gun and aim it. I didn't have to use it. Braden Jarrett says, I didn't want to pull the trigger on that guy. He said, that would have been a whole different situation. But when I knew when it first happened, I had to stay calm. He did. And thankfully, like the vast majority of defensive gun uses in this country, the presence of that firearm was enough to convince the suspect that he had somewhere he needed to be very quickly. So again, should Ashley Jarrett be facing charges? I would say no. But gun control activists would say yes. That Braden Jarrett should not have been able to get a hold of his mom's gun. That he should have called 911. He should have maybe tried to run out the back door. But he should not have been able to access that 9mm handgun. He should not have known how to safely and responsibly load it. He should not have been able to have access to that gun, according to them, and Ashley Jarrett should be facing charges, in their view. See, I don't think it's as simple as that. I don't think it's as black and white as that. I think we can look at a situation and say, yeah, should a 6-year-old have been able to access a firearm and bring it to school? No. Is there some sort of charge that might be appropriate for the mom? Yeah. But maybe it doesn't involve a firearm. Maybe it's not a safe storage law violation. Maybe it's, child endangerment. Maybe it's neglect of a child, right? Because if the 6-year-old had brought a really sharp butcher knife to school and had stabbed the teacher instead of shot her, that still would be bad, right? I mean, we still would be talking about how terrible a situation this would have been. So maybe the answer, again, is to look at the parent, to look at the child, to look at the totality of the situation rather than simply try to apply a one-size-fits-all rule that could very well end up putting some juveniles at risk. All right, today's good deed of the day. In the right place, at the right time, willing and able to do the right thing. A good Samaritan in Georgia who helped find a missing 10-year-old child who had run away and helped to reunite him with his mom. The image when mom and son were reunited. And I got to tell you, this is such a, I feel so bad for this 10-year-old child. His father apparently had just passed away, was not dealing with it. Mom was trying to take him to a children's hospital there in Atlanta. Don't know if this was for unrelated medical care. Don't know if this was for, mental health help or emotional health help. But for whatever reason, the 10-year-old named Mario Boyd ended up running away out of the car as they got close to the hospital. Mario's mother, Chenrika Boyd, said, I was really just out of it. I didn't know what was going to happen or if I was even going to see my child again. So, she alerts police. She's on social media. She's posting pictures. Help me if you can. And about 15 hours after Mario Boyd ran away, she heard from somebody on social media saying, listen, I found him and I'm taking him to the hospital. And she was able to reunite with her son there. She said, I didn't do nothing but was kissing him and telling him how happy I was that he was okay. According to WSB in Atlanta, family members again say that Mario was going through a crisis because his father had recently died. Family says he was barefoot when he ran away. But Chenrika Boyd says the Good Samaritan, quote, dressed him, let him stay at home for a little bit, clothed him, and then again, took him to that local hospital where he can get the help that he needs. Chenrika Boyd says, I want to tell him thank you, and I appreciate you helping us out. And that really is, going above and beyond in the right place at the right time, willing and able to help out a child in need. So whoever this anonymous Good Samaritan is, we thank you for your very good deed. Now, that is all the time we've got for you on this edition of Bearing Arms Cam & Company. I will encourage you again, check out bearingarms.com throughout the day because there's a lot of stuff going on. A lot of moving parts right now. A lot of court hearings. We could get a good decision out of Illinois. And there's a lot more on tap as well. So we'll see you on the website. If you like what you see, I'd always encourage you to become a VIP member as well. Just go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. As our way of saying thanks for showing your support, we're going to give you exclusive news stories and commentary you won't get anywhere else because your support does matter. And it really does make a difference. So thank you again. Enjoy the rest of your Hump Day Wednesday. We'll be back here tomorrow with another edition of Bearing Arms Cam & Company. Until then, be well, be safe, and be free.